All right, ladies and gentlemen, thank you for joining us today for the second and fourth conference call series hosted by the Kelly Group at Morgan Stanley. Conference calls that happen on the second and fourth Thursday of every month at 12 p.m. and 5 p.m. Central Time. We're very exciting to have a special guest with us today for round 2 of the 5 o'clock call. We are joined by Kristen Marks, who is an author, speaker, and Florida wills, trust, and estates attorney. Kristen is the founder of My Pink Lawyer, Pensacola-based estate and succession planning law firm, which helps Florida families prevent bad mistakes from happening when a loved one dies. My Pink Lawyer customizes estate and succession plans that avoid confusion about your wishes, minimize family conflict, make the transition of assets as simple as possible, oftentimes without unnecessary court and government intervention, and minimize taxes and legal expenses. Kristen has authored a great book, Wise Women Protect Their Assets, an essential estate planning guide for smart women, which you may order from her website at www.mypinklawyer.com. In her spare time, Kristen loves to spend time with her family, ride her Peloton, meditate, practice yoga, travel, and train for ultra-distance trail running races. We are very excited to have her again, and to get the conversation started, I'm going to pass it over to our very own Lori Potachik.
Thank you so much, Asher. I really appreciate that. And Kristen, definitely appreciate having you on the call for the second time today. I know the first call this morning was very informative, and we had some good feedback already from that call, so I'm looking forward to the second call. So just want to first say thank you for being on the call today.
Thanks for having me.
You are so welcome. So 30 minutes goes by very quickly, as we learned on the first call, and all of these calls really that we do. So I want to go ahead and just kick things off. So today we're talking about trust, more specifically living revocable trust. So I'm just going to get right into this, Kristen. So what exactly is a living revocable trust? And maybe you can even expand upon that and tell me if I need one.
Okay. So a living revocable trust, in its simplest terms, it's just a written document that expresses your wishes about who you want to inherit your assets when you pass away and who you want to put in charge. So it's similar to a will in the sense that it is a written document. But how the documents are carried out in practice are very different between a will and a living trust. A living trust, when it's structured properly and properly funded with your assets, can avoid probate of your assets in the future, whereas a will does not. A will, all it does is provide written instructions to a probate judge about who you want to inherit your assets and put in charge. But in a nutshell, that's what a trust is. If you were just to look at it, it's just pieces of paper that you have signed and it has words on it, but it does have great significance in terms of expressing your wishes in advance about who inherits your assets. In terms
That's
of
great. Well, can I pause you for just a minute because you mentioned something that comes up a lot on our calls, and that's probate. So there's a lot of misconceptions around probate. So maybe you were going into this, but can you tell me how can I avoid probate? Because I think a lot of people have the understanding that maybe a will does help them avoid probate. And from what you've just said, that's obviously not true.
Yeah. So even to back up further, why is probate even necessary if somebody dies? Because
that's a great idea.
When someone dies, not everyone, there isn't always a need for a probate when somebody dies. And so there's a lot of confusion about why did, when my aunt died, the family needed to probate her estate, but when my brother-in-law died, my sister didn't have to do that. Why is that? Well, it really depends on the nature of a person's assets when they die and how those assets were titled, if those assets had beneficiaries tied to them, and maybe if those assets were owned by a trust. So basically a probate becomes necessary if someone dies and they have assets that were just in their name, they weren't co-owned with somebody else, there were no beneficiaries tied to them, and now that the person has died, they are not here any longer to sign that asset over to their intended beneficiaries. So that's where a probate becomes necessary. A probate judge appoints somebody to stand in the deceased person's shoes and gives them the legal authority to wrap up the deceased person's affairs and to transfer assets out of the deceased person's name into the name of whoever's supposed to inherit those assets. And that court-appointed person in Florida, we call them a personal representative. Some states use the term executor, but it means the same exact thing. But that's why sometimes when a person dies, a probate is necessary, whereas in other cases, it's not necessary, because in the cases where we don't need the probate, the person who passed away had their assets structured in such a way as to avoid the necessity of a probate. They might not have realized that they did it that way, but that's how it shook out. But that's why our clients work with professionals like you or myself to get their ducks in a row and make sure that, hey, when I die, is this account, or is the money in this account going to pass to my intended recipient? And how do I make that happen? And if I can make it happen in such a way that it's seamless and inexpensive, and we don't have to get the courts involved and pay a bunch of legal fees, then that's ideal. That's the ideal situation. And that's what we try to do for all of our clients. Not always possible based on just different situations, but that's our starting point. That's usually our end goal when we're working with clients.
Yeah, and I'll add to that, that life is going to change and situations are going to change along the way. And so reviewing that, making sure that there's some consistency, that it's checked on a regular basis with your professionals is obviously a great idea as well, because things do happen, and we want to make sure that we account for them. So how often would you say that they need to review some of the documents that they have?
Yeah, so my rule of thumb, and it's probably, I think your rule of thumb as well, is every 3 to 5 years, even if you think nothing has changed in your situation and in your life, every 3 to 5 years is a good rule of thumb to touch base with your advisor again and talk through what your plan currently is, what's going on in your family, and what assets do you own at that point. Because you might think nothing's changed, but really you forgot, oh, you know what, I forgot I opened that CD over in this other bank because they were offering a great introductory rate. But I forgot to assign a beneficiary for that account. Well, that's something that your advisor is going to, when they audit your assets, say, okay, there seems to be a little hole here. How are we going to plug that hole and make sure that account gets where it needs to go when you pass away? But I know the purpose of this call are trusts, Lori, and living revocable trusts are just one tool that we have at our disposal to avoid probate when you pass away. We have other tools as well, but a living trust is a tool that we always have at our disposal if there are not other mechanisms that would work better.
So do I need one then?
Well,
does everybody on the call need a living trust to avoid that probate?
No, not necessarily. So anybody listening on the call, kind of my analysis in my head when I'm talking to clients about what their assets are, and I know that their goal is to try to avoid probate. I imagine that there are 4 buckets sitting on the table. And 3 of those buckets will avoid probate. 1 bucket does not avoid probate. So I always start with the 3 buckets that avoid probate first. So the first bucket that avoids probate are any assets, Lori, that you co-own with somebody else that have an automatic right of survivorship tied to it. For example, a married couple that co-own a house or maybe a bank account, they co-own anything together. The presumption in Florida for a married couple is that there are rights of survivorship between the 2 of them. In other words, as I like to say, last man standing wins, right? So my husband and I own our house. If I die first, he continues to own the house. He doesn't have to do anything to prove he owns it. He already owns it 100%, and he continues to own it 100% after my passing. If, however, I co-own a rental property with you, Lori, the presumption is the opposite. Since we are not married, the presumption is we each just own our 50%. And if one of us dies, we have the right to leave our 50% to whoever we want. So that type of a situation would not fall in that first co-ownership bucket because we don't have the automatic rights of survivorship. Now, the second bucket that avoids probate without it being a trust are, a lot of clients have assets in this bucket, and those are any accounts, usually financial accounts, life insurance policies, retirement plans, banking accounts, and sometimes even real estate, where the client has assigned in writing a beneficiary for that particular account or asset. So think CD at the bank. You can sign a beneficiary form for your CD. When you die, this is the person that I want to inherit the CD. A life insurance policy, you can sign a beneficiary form. Retirement accounts, you sign a beneficiary form. Brokerage accounts, you can sign a beneficiary form. Even real estate in Florida, you can assign a beneficiary using a special type of deed in Florida that we call a ladybird deed. So that's a special type of deed for the right situation where you can designate a death beneficiary of real estate when you die. So if your assets have beneficiaries on them, they fall into that second bucket that is already going to avoid probate when you die. The third bucket, which is the purpose of this call, is a living revocable trust. So any assets that are owned by a trust also avoid probate when you die, because if your house is owned by a trust, even though you might die, or we all will die, but so whenever you die, the trust is still the legal owner of that house. The trust has not died. And the trust document says, okay, when Kristen dies, this house is to automatically pass to, Lori. And I'm putting so-and-so in charge. I'm putting Chris Kelly in charge when Kristen dies to make that happen. And
oh, no.
So that third bucket is a living trust or some other type of trust where your trust owns your assets. Even though you've died, the trust dictates what happens to those assets when you pass away. So to get back to, circling back to the answer to your question, Lori, if one of the planning goals is to avoid probate of assets when you die, you just need to make sure that your assets fall into one of those first 3 buckets. If all of your assets already fall into buckets 1 and 2, then there's really no reason to set up a trust because we've already taken care of avoiding probate through buckets 1 and bucket 2. Now, just to carry the analogy further, I said there were 4 buckets. The 4th bucket is the everything else. So in other words, if you own something that's not in bucket 1 because it's not co-owned with the right of survivorship, it's not in bucket 2 because there's no beneficiary tied to it, or a beneficiary designation would be complicated for various reasons. For example, your beneficiaries would be minor children or disabled children or somebody that really should just not inherit a lump sum when you die. Beneficiary forms aren't the best tool then to leave money or assets to that person. And if your assets aren't in bucket 3 in a trust, well, then they fall into bucket 4. That means it's an asset that's just in your name, no co-ownership with rights of survivorship, no beneficiary, it's not owned by a trust. When you die, you are not here to sign that asset over to your beneficiaries. This is, again, where the probate court comes in and says, okay, we're going to appoint such and such person with the legal authority to transfer these assets out of this 4th bucket now that this person has died. But a lot of people mistakenly think, Lori, that if they have a will, that a will avoid probate of their assets when they die, and that is not the case. So just to understand what a will can and can't do, number one, a will only controls the assets in that 4th bucket. So let's say there's a discrepancy between what your will says and what a beneficiary form says for one of your accounts. This comes up a lot in my practice. Beneficiary forms, buckets 1, 2, and 3, always take priority over bucket 4. So if I have an account that says I'm leaving this account to my spouse, but I have a will that says I leave everything to my children, well, which do you think is going to win? It's going to be the beneficiary form always takes priority over the will. So if I don't even have assets in that 4th bucket, my will might be a moot point. Or I might have a lot of assets in bucket 4. If they don't magically avoid probate, but at least I have a will that can be presented to the probate judge to say, okay, Judge, Kristen died, but here's her will. She wants to give the assets in this bucket to her kids, and she wants to name her oldest child as the personal representative to make all of this happen. And that's how we handle bucket 4. Now, I'm probably giving you way more information, Lori, than you want.
No, that's all great information.
One final thought about bucket 4 is that, okay, in bucket 4, what if I don't have a will, but I have assets in bucket 4? Well, we still need to open a probate, but now state law is going to dictate who inherits my assets, because I didn't get my act together to have a will to cover bucket 4. Now the state has rules on the books. If Kristen dies, these are her legal heirs, and this is who's going to inherit this bucket. And sometimes my legal heirs might be in alignment with who I really want to inherit, and other times it's not in alignment with who I would want to inherit. I've worked with clients before that had been married for years, but they had a child when they were super young. They don't even have a relationship with this child. They don't even know where this child is anymore. Well, it doesn't matter. That is a legal heir of this person, and they can be entitled to assets from that 4th probate bucket, even if you have zero relationship any longer with them. So that's basically my job, is to look at, okay, what are we working with? What do you own? I'm thinking in my head, what bucket do all of your assets live in? Who do we want them to go to? and utilizing the tools from the various buckets. How can we set all of that up to make it happen, to get your assets to your intended folks as quickly and easily and cheaply as possible in the future?
Well, I'm glad you clarified on that. Absolutely, it really did. And I'm glad you clarified and expounded on that, because unfortunately on my side of the table, Chris and Sydney and myself find ourselves where people have lost loved ones. And it may be loved ones that weren't working with us, who had or maybe didn't have professionals in their lives that were helping them set these buckets up, so to speak. And when they don't have the direction, whether it be, the beneficiary being named or a trust or a will, when they don't have that direction, it can be very difficult from an emotional standpoint, and it can cause family division. It's so much easier for our loved ones when we go to leave those instructions, preferably by buckets 1, 2, or 3 than it is for probate, just because of the cost. But it's incredibly helpful, not just to make sure that our assets pass on to our loved ones the way that we intend, which obviously is incredibly important, but also so our loved ones don't have to suffer the stress of trying to figure that out after we're gone as well, and possibly knowing things were supposed to go one way and maybe didn't go that way because they didn't take those steps. So I'm really glad you expanded on that. So let's just say I'm somebody sitting on this phone call today, and I'm listening to your buckets that you've mentioned, and I decide, I think I might need one of those living trusts. I feel like the first question that always comes to mind is, how much does it cost? So can you tell us, are they expensive? Are they inexpensive? What are we looking at if we want to purchase something like this?
Yeah, so in a nutshell, typically using living trust as part of your plan, it is going to be more of an upfront investment than if we're using buckets 1 or 2 to make things happen. But sometimes buckets 1 and 2 just are not going to do the job, right? So, for a variety of reasons that I won't get into, it really depends on the situation. I always try to utilize buckets 1 and 2 because those are typically cheap, easy ways to avoid probate, but they're just not always appropriate for every client situation. So that's when we can always turn to a living trust, bucket 3, to own assets. In terms of the cost, in our office, we do everything on a flat fee basis for your entire plan. Your entire plan would include things like wills or trusts, documents to pass along your assets when you die, but also would include powers of attorney for financial matters, medical directives, to make sure that you have folks in place to assist you financially and on the medical side if there is a need during your lifetime. For example, you become incapacitated. Okay, setting the stage there for the flat fees. If a client is a good candidate for a living trust-based plan, you're probably looking in the $3,200 to $4,000 range, depending on whether we're talking an individual client, a married couple, how detailed or complicated are we getting into the drafting of the trust in terms of who's going to inherit? Are we building in additional trusts that will come into play in the future for your beneficiaries? For example, if they're minors or they're disabled or they're just bad with money, so you want to put guardrails around their inheritance. All of that plays a role in the quoted flat fee. But even in that fee range, it still is a heck of a lot cheaper than your family having to open a probate for you. That can cost $10,000 in Florida. Easy. There are some more inexpensive probates, but it can also go way higher than $10,000. So think $8,000 to $10,000 for probate versus, okay, still in the $3,000 to $4,000 range for a living trust. I'm still saving everybody money by using the trust. And a trust is a very flexible estate planning vehicle, so long as we keep it current, and by current I mean not just is this still documenting your wishes accurately, but current in the sense of are all of your assets actually in your trust at all times, even if you acquire new assets in the future. But it's flexible in the sense that your trust can own assets out of state. It's flexible in the sense that you can, once your assets are in your trust, if you decide you want to make changes to who your beneficiaries are, you can change just one document. You don't have to go back to all of your financial institutions and sign new beneficiary forms everywhere. So it's kind of like a one-stop shop. Once we set it up, then you can just come to me and we can revise the document, and you don't have to keep going back to Lori to sign new beneficiary forms for all of your accounts with Morgan Stanley, et cetera.
I didn't get that. Could you try again?
Nope.
Uh-oh.
That was my watch talking to me saying she didn't understand.
She wanted to participate in the conversation.
Yeah, as long as you understand, Lori, and the callers do.
Well, so living trusts sound pretty good, and obviously, even though they can be quite expensive compared to what somebody might face in probate, it sounds like it's a pretty good deal, and it's probably the better route to go. So, what disadvantages? And I know we're running shorter on time, but are there any disadvantages to having this?
The first one, obviously, added expense, right? More expensive usually than some other planning vehicles. But sometimes it still just happens to be the best vehicle to get the job done. So added expense is one. Number two, sometimes it's just hard for people to, visualize the concept of what this trust is, and they don't understand that they wouldn't be giving up their rights to their assets with this type of a trust, that they don't have to file separate tax returns for this type of a trust. So sometimes, simplicity is just important for people. I get a beneficiary form. I don't get, Kristen, what you're trying to tell me what this trust is all about. Thirdly, a third disadvantage would be always making sure your assets are actually in your trust, because your trust does not do you a hill of beans for anything that you haven't put into it. So if you set up a trust, you need to make sure that you're working with your advisor to retitle assets either into your trust or signing beneficiary forms that designate your trust as the beneficiary of your assets. And as you acquire new assets or accounts in the future, you make sure you put them in your trust again. So that's something that your advisor will help you with as long as you are staying in touch with them.
Yeah, and I'm not sure what that noise is, but
I'm sorry.
I know we
I'm
mentioned
out on my porch right now, so there's somebody out at the porch.
That's okay. I know you mentioned it earlier. Sorry.
They're having fun.
I can hear that.
See? Who knew it was so much fun?
It sounds like they absolutely are. I know. They're celebrating this fact. And with that, I lost my train of thought. So, I'll actually just go into the next question I did want to hit on before we close out, because this is something that you mentioned earlier that you're asked a lot about, and I think there's some misconceptions around, but does a living trust protect our assets from creditors?
No. Simple answer, no. We can end the call. No. So your living trust does not provide you any more or less asset protection than your assets themselves. So in Florida, we're very fortunate. We have a lot of assets that our creditors are not allowed to get to anyway. For example, our home. Unless you don't pay the mortgage and they foreclose, your general creditors cannot take your house away from you. It is legally protected in the Florida Constitution that your creditors can't take your house from you. They also cannot go after retirement monies in Florida. That's a biggie for a lot of clients. A lot of their wealth is tied up in retirement monies. Your creditors also can't go after certain types of annuities or cash value of life insurance. But the other biggie they can't go after are joint ownership of assets, jointly owned assets between a husband and wife. So the nature of the asset is really going to dictate the asset protection, not the trust itself. And another thing that clients sometimes mistakenly think is that, oh, I'm going to use this trust because it's going to save me taxes. No, your living trust is a tax neutral entity. In other words, it doesn't save you any more in income taxes. It doesn't cost you any more in income taxes. And in fact, you don't even have to file a separate tax return for a living trust while you're alive. It's still, everything's your 1040. You don't even need to file a separate schedule like you would for an LLC or an S corporation.
Yeah, I'm glad you brought that up because I know that is a big misconception as well. Unfortunately, Kristen, 30 minutes has gone by just like that again. So I do want to say I appreciate your time. I will tell everybody that's listening in on the call, as somebody who has read Kristen's book, it's fantastic. She gives a lot of really good examples that I feel like are very relatable to and makes you think about things that maybe you hadn't considered. So I would encourage you to look into getting that and just reading through it. But as
and they
always,
can just download that from my website.
Yes, that's great. And if you need that information, feel free to reach out to us, or if you have further questions, we'd be more than happy to talk to you one-off. So you can give any member of the Kelly Group a call, and we'd be more than happy to talk to you. But, Kristen, again, just thank you so much for your time, and I really appreciate everybody that's dialed in today, and definitely look forward to having more of these in the future.
Thanks, Lori.